Perfect. Awesome. So welcome, Kate. Thank you very much for
Hi.
attending and presenting today on the session. As always, if anybody's got any questions, please put them into the chat. If likewise, are you okay for interruptions as well, Kate?
Oh yeah, absolutely. Definitely love that.
Okay, fantastic. Yeah, so sort of over to you to share your screen and
Yeah,
start your
great.
presentation and introduce yourself, if that's okay.
Okay, perfect. Thanks so much, Ollie. Thanks everyone. Right, I'm
Thank
just
you.
going to yeah, share my screen. I've got a little presentation for everybody to take a look at.
Excellent. We can see that.
I'm just looking for the, where's
Bottom
my
right-hand corner. There you go. So yeah, next to the minus icon and the magnifier. Perfect.
Thanks, Ollie. Okay, right, delving straight in. Thanks so much for waiting, everyone, and welcome to today's session. My name's Kate Hollier. I am an immigration solicitor over at Chatterton's, working from home now, but I'm normally based in the Stamford office. And yeah, I've joined in September to head up the immigration department. Hopefully you're all a little bit aware of UK immigration, maybe know a little bit about what's happening, maybe you're employing people now that you're requiring, you need to follow the immigration laws and requirements. So as I spoke about just before everyone joined, I don't want to be talking at you constantly for the full hour. I'm wanting to talk to you today and give you a little bit of flavour about where we are now with UK immigration in light of Brexit. Specifically with regard to EU nationals, both living in the UK now and EU nationals going forward, coming into the UK. And I'll also be focusing a little bit on the changes to people working in the UK who are from outside the UK. So there's my info, which can be shared with you afterwards, should you need. And I'll just go straight into, okay. So yeah, looking at where we are now, you'll see plenty of press reports and constant articles in newspapers about UK immigration. The UK does remain a very sought after destination. The legal system is seen to be just and non-corrupt. There's families who want to have their children enrolled in UK education. So overall, it's still a really attractive place to come and for workers to come to. And yeah, it's a heavily politicized area, so very exciting for me to work in. There's still an element of the hostile environment, words coined by Theresa May a while ago, whereby, yeah, it's harder to get here, harder to stay. In my almost 10 years working in immigration, I have seen these peaks and troughs of, you know, clamp down in UK immigration, lots of refusals of people trying to come into the UK, and then gradually you'll see the follow on from that, whereby it frees up a bit, opens up a little bit more. So we're in a bit of a flux at the moment, and yeah, as far as where I come in, we're seeing the law, the UK immigration rules. You may or may not have delved into the wonderful laws of immigration, but the rules themselves are pretty convoluted, pretty badly drafted. I really hope we've got no one from the Home Office listening in, but it takes a lot of translation. So that's part of my job. A large part of my job is translating this law into the English language so that we can actually follow it and know what is required. So how can I help you? What I do is I advise both individuals and businesses on immigration law, how to comply with it. This generally involves applications, so on the whole, visa applications to the Home Office, for permission for individuals to come into the UK and to stay here. And this leads all the way up to, you might have heard of settled status, settlement, indefinitely to remain, different words that broadly speaking mean the same thing. And then the final stage, if that's what an applicant wants, would be the British citizenship and the British passport. So that full spectrum from entry to end result, potentially passport, and everything in between. So visitor status, people coming here on a temporary basis, anything that involves coming into the UK and wanting to stay in the UK for non-UK nationals. I also deal with, when things go wrong. So like I spoke about before, we see a lot of refusals of visa applications, refusals of applications for leave, for permission to stay in the UK. So that's where I can come in as well and help advise on that and go to the tribunal to argue against that refusal. As far as the cases clients are concerned, I've mentioned that I can advise individuals and businesses alike. Businesses on the whole, advising on employing people from outside of the UK. And this involves sponsorship, which I'll go into later. But huge variety. In the past, I have also worked a lot on advising high net worth people and politically exposed people who are wanting to come to the UK as that safe haven where the legal system is seen as just. So people escaping persecution from countries like Russia, Ukraine on the whole in the past kind of 8 years or so ex-CIS countries. Is that going to allow me to go to the next stage? So what I'll just give you a breakdown of what I'm going to talk about today, and just to reevaluate where we are right now with this system. So I'm sure you're all more than aware that the UK has left the EU now. Free movement, which is when we were part of the EU, allowing European EEA nationals and British nationals to travel to and from different EU, EEA countries, that free movement has come to an end. And so now we see that European Union and EEA citizens are subject to exactly the same UK immigration rules as everyone else who's not from the UK and not Irish. So I've never had to advise so many people as I do now, because immigration really does touch on so many more people now. Obviously with the pandemic, we see less physical movement, but these rules apply to everyone. So we're no longer looking at the EU regulations for residency status. And the UK has, they say that they've introduced this whole new wonderful immigration system. This is what's been plugged by the government. This immigration system that's said to be following Australia's lead, points-based system. I mean, in short, what I would say is there's been a rebranding, but on the whole, the menu of options remains the same. There's nothing particularly new and exciting. We've got rebranding of the titles of the different visas. We've got plenty of additions to those UK immigration rules that I mentioned before, plenty of new law, but on the whole, it is the same. And we've just seen that all of these different categories now apply to European Union EEA nationals as well. But the aim of the government that we're seeing is that they still want to attract these high net worth investors, these entrepreneurs who are going to set up amazing new businesses, and skilled workers. That's the key change. The skilled worker category, by and large, is the same as the tier 2 general that you might have heard of before, but we'll delve into that in a little bit. So this new post-Brexit UK immigration system, I'm going to be talking today about EU citizens living in the UK. Hello, anyone? Oh, thought that might have been someone wanting to chat, but again, just to repeat, if anyone wants to jump in with any questions, I'm more than happy to pause my little presentation. So just do shout out. So first of all, I'll be just talking about EU citizens, EEA citizens who have been living in the UK as of last year, 31st of December 2020 and before, and what they have to do now. Also options for EU EEA citizens who want to come to the UK from 1st of January onwards, so post-Brexit, pre and post Brexit, and then also how to recruit from outside of the UK now. So, firstly, EU citizens living in the UK before Brexit. If anyone, EU citizens living in the UK before Brexit, there was no requirement to have any kind of documentation. So I've seen, Portuguese citizens living here for decades and decades and decades, no need for any documentation because all you've needed to hold up is your Portuguese passport or your European passport. There was the possibility of applying for different residency documents, but that wasn't a strict requirement. Family members of EU citizens as well have always been able to join their EU citizen family member in the UK, living in the UK, as long as that EU citizen is exercising treaty rights in some way, which means, working, studying, being self-sufficient here. So, everything's changed now because we've come out of that. We've had EU citizens now enveloped into this UK immigration system. So the domestic law now applies. And this means that EU citizens have to apply to get residency documentation, regardless of whether they've had it before. They have to get this new residency documentation. There's only a few categories of people that do not have to get this documentation, such as people who have very historically been granted indefinite leave to remain. Generally, my advice is, even if you're unsure, just apply. We've got this deadline of 30th of June 2021. So if anyone knows any EU citizens living in the UK, or anyone is one, or you're employing anyone who's an EU citizen in the UK and who was here before the end of last year, and the cutoff for that is basically 11 p.m. on the 31st of December 2020, we've got to have this 30th of June 2021 deadline flashing. It's vital that anyone who can does apply before then. I think they've had a huge amount of applications made to this system so far, this EU settlement scheme, but not enough, and the number is not reflective of how many EU citizens we still have living in the UK. No crystal ball to see what's going to happen on the 1st of July 2021, but that scheme is going to be closed and to new applicants. And if those people haven't got that documentation, haven't been registered on the EU settlement scheme, then I think there's going to be a lot of litigation, basically. So plenty of work for me, I'm sure, but it's not ideal. So really want to be spreading that message now. Apply to the EU settlement scheme. It is a really straightforward system, so no one need be afraid of applying. As I said before, you've got people who've lived here for decades and decades, always felt free and easy about living in the UK, and it's a big deal, and it is quite scary as well to a lot of people to think, oh, I've got to be registered. It's an immigration issue. It automatically makes people, or it certainly would me, feel under pressure, feel kind of watched, but it's a free application system. It can be incredibly fast. Essentially, if you've lived here for longer than 5 years, up to 31st of December 2020, then you want to be applying for what's called settled status. And that's the same as sort of permanent residence, indefinitely to remain. It's all these different words and expressions that mean basically the same thing. So settled status it lasts forever. You've got to maintain it, though. If you do leave the UK for a set amount of time, it can be lost. If you haven't lived here for 5 years onwards, but if you've literally just come into the UK on the 1st of December last year and got a utility bill, got a pay slip, then you can apply for pre-settled status. So that gives you this gives you a 5-year grant, and at the end you're expected to apply for settled status, or it falls away. Pre-settled status can be lost as well if you spend 2 years in a row outside of the UK. The reason it should be quite straightforward to apply is that the Home Office shares information with government bodies such as HMRC. So if you've got an EU citizen who has worked and had pay slips for many, many years, or self-employed and been paying the tax for every year, then it's going to be pretty straightforward for the Home Office to confirm those details and just issue the documentation. It's worth mentioning, documentation-wise, that there's no, I mean, if you're a family member of an EU citizen, then you can get a residence card. So if you're not EU yourself, if you are French, Spanish, Italian, EU, then the status is actually electronic. So digital era, you are able to share your status with potential employers or such like if you want to prove your status, but it's all done electronically now. And yeah, that would make you free to work in the UK. I would just mention that if you are an employer who is employing EU citizens, encourage them to apply. You cannot, and this is an employment law point of which I'm not an expert, but I do know this, you cannot request to see documentation or evidence of applying. That's totally up to the EU citizen themselves. So you can't be asking that until after June 2021. So we can talk about that a little bit later on as well. Okay, EU citizens coming to the UK from 1st of January onwards who have not lived here. They, as I've said, they all come under the same umbrella now as non-EU citizens. So I won't delve into detail about all the different visa categories because that would be ridiculous today, but you've got your standard family visas. So that would cover, so the spouse of a British citizen, for example. Student visas, you've got long-term student, short-term student visas to come and study in the UK, and then different categories of work visas so that you can work in the UK. So yeah, EU citizens are the same as non-EU citizens, and they would be falling into those to have to meet one of those or have to apply from the menu of options now. Visiting wise, on the whole, no visa is required for EU citizens to come to the UK as long as they are undertaking what's known as a permitted activity. So you've got to be really careful coming to the UK and doing some work. You can come for a permitted paid engagement, but you've got to make that really clear when you are entering the UK and potentially apply. Just something to be wary of, and I won't delve into any more detail than that. The family and the student routes are generally the same. So again, I'm not going to go into further detail, but there are a couple of useful categories for EU citizens who are looking to work in the UK, specific categories that, and we'll talk about employers that have to be a sponsor to sponsor EU workers, but whereby you've got an employer who's not going to be a sponsor, there's this frontier worker permit. That's one of the new categories. Really interesting, I think, and can be quite flexible because it's not, it's only applicable to EU EEA nationals. They have to be resident overseas or normally resident overseas, so not in the UK, which on the whole means don't spend more than 6 months in the UK. And if they have worked in the UK at least once, so literally for a week, in the 12-month period before the end of December last year, so in 2020, then they can get what's called a frontier worker permit. It lasts for 5 years as long as the person carries on doing that kind of at least once a year work in the UK. And yeah, this is going to be quite an interesting one, I think, because it's a pretty broad remit of the people that can apply. The reason it was created, as far as I understand, is for people who are sort of on the borders and regularly travel to a different place to work and then go back home, that kind of thing. However, yeah, if you've got anyone that you know or you yourself have worked in the UK, then returned to a different country, then that might be an interesting one to consider. Also, there's certain temporary worker categories that don't require a UK employer necessarily to be a sponsor. We'll go into more detail on that in a little bit, such as there's the seasonal worker visa. This has been in the pipeline for a long time, and it's been called different things, but the government does seem to recognise that following Brexit, we're not going to be able to have, or many EU, EEA citizens aren't going to be able to come here every year to carry out the seasonal work that the UK requires. And they've introduced this route that has a cap of, it's 10,000 people now per year. And there are two overarching sponsors that have been chosen. So it's, if you're involved in the agriculture sector, it's Concordia and Proforce Limited that have been chosen by DEFRA, so all agriculture chat there. They act as sponsors. So potential seasonal workers apply to them. And then you've got your, for example, UK farmer applying to that overarching body, DEFRA, Concordia or Proforce, to match up a worker with the needs of, say, a farmer. That seasonal worker visa is valid for 6 months. It's still in its early stages, and as I say, there is a cap. So they increased the cap, but I mean, it doesn't, I don't think it's going to be enough. So we'll have to wait and see how that works, whether that gets increased through the year, whether we've got enough workers to carry out the work that is required. I mean, I've got to be in my bonnet about this system anyway, so I'm not going to bore anyone with that right now, unless you'd like to chat to me about it specifically. But yeah, the idea being that we need to rely on UK workforce and more, etc., etc. So moving on to that third point I wanted to discuss, recruiting from outside of the UK now. Yeah, as I said before, you may or may not have heard of that tier 2 general category. That was the general work visa, the way that you could sponsor someone from formerly outside of the EU to come and work for a UK business. This has been rebranded, one of those classic rebranding, but there are some key changes that I'll talk to you about. It's now called just the skilled worker category. And this opened just before Brexit was complete. So 1st of December it opened. And it's, yeah, for anyone coming to the UK as of 1st of January, so very much now. Without going into too much detail about how the previous category worked, basically now, well, there used to be this cap. So every month you'd have to kind of check how many of these visas had been granted to see whether one person could make this application and potentially have to wait till the next month. So now there's no cap. So very much free for all. Also, you may or may not be aware that previously you did have to carry out what's called a resident labour market test. So a UK employer who had this star employee that they wanted to bring across ASAP to start the job would have to carry out this 28-day advertising to UK residents in order to make sure that there was no one in the UK already who was already settled here or British that could take on the role. And I mean, this is a great move that they've got rid of this, because it ended up just being a sitting waiting game, basically. The whole idea of the skilled worker and previous tier 2 general worker is that it's got to be genuine employment. You've got to have someone who is skilled and specific to this role. By the time you're coming to this point of applying for the visa, you've already, scaled it down and you know who's going to be good at this job. So yeah, resident labour market test is gone. That doesn't mean, however, and this all links into employment law, that there's no need to kind of keep records of the recruitment process. There very much is. You've got to make sure that the recruitment process has been genuine, has been recorded, keep all records. Yeah, so the thing about the skilled worker visa is that it's kind of cranked up the minimum skills level. So it goes back to what the UK is wanting right now. It's wanting what it classes as not skilled work to be completed by people in the UK, and only to be bringing across what it deems as the brightest and the best to do this skilled work. So you might see this RQF level 3. Don't worry about what that actually means, but it's basically the job itself has to be A-level standard or above. It's not up to the employer to decide or to state whether they believe it is. The Home Office has produced, or has always produced, this long list of categories of different types of role. So the employer has to look at the role that they want to employ for, look at this huge list of, it's coded, so they're called SOC codes, look at these codes and try and match up how best, which one the role is going to fit into. And that particular code will give an example of what they would estimate the basic salary should be, and what the general points of the role would be, main points. So it's a little bit of a complicated, convoluted system, still hasn't changed, but that's how they want to make sure that it is that A-level and above role, skilled. The big change with this new skilled worker role is that there are these tradable points. So as well as that labour market test falling away, you can now, and this is what I think they've copied from Australia, but you can trade points. So there are the mandatory points that you have to score, and I'm going to go on to this on the next slide, and the tradable points that if you don't meet the salary threshold. This is all, this skilled worker route, this is the skilled worker visa. It requires, someone's just coming in now, it requires the employer to have the sponsor license, which maybe a lot of you already have if you've got companies. I'm getting a bit of reverb. Oh, is that better? Yeah, that's great. Thank you for just turning off the mic. That works a lot better. So yeah, these require the UK employer to have a sponsor license. And this I will talk about as well in a little bit, go into a little bit more detail. You've got to sponsor the skilled worker, and that in itself has a huge amount of responsibilities. And to get a sponsor license, again, it's a process. There's a lot of cost involved, time waiting. Not by any means impossible, but we'll look at that as well. So yeah, going back to, this is recruiting from outside of the UK. This is a skilled worker route, which requires the visa itself, but then it requires the employer to have a sponsor license, which is another application. Okay.
Hey, just on that, can I possibly ask 2 really quick questions, please?
Yeah.
So with regards to the skilled roles, is there any criteria for experience, or is it just going to be based purely on academic qualifications? And the reason, sorry, go for it.
Oh, no, please go on. Yeah, what's the reason? Yeah.
Purely and simply because when we've looked at doing this in the past in various organisations that I've worked for, on paper 2 people can be identical. In terms of experience and background, very, very different. Is there any dispensation for basically experience over qualifications, or is it purely a qualifications focused process?
Yeah, it's not. I mean, that A-level, yeah, maybe that's a little bit misleading. That's that they class that as the level above, but as we all know, you've got roles where someone is super successful and skilled in their role, and they haven't necessarily got any A-levels. It really doesn't matter. So that is purely a kind of guide to think of the type of roles that are considered as skilled, but that's not a requirement. And those, and qualifications wise, I'll go on in the next slide about tradable points, but qualifications wise, it's not necessarily qualifications. Yeah, it's based on experience, based on who's right for the role and what they've been doing before. So thinking about, I mentioned that genuine requirement. And this is all what the Home Office would look at. There's no, albeit this is very much, you know, have you got this point? Have you got this points? Have you got these, scored these points? There is a huge amount of subjectivity in these applications, which is where a lot of people end up falling down with these applications, because the Home Office, the caseworker will be looking at this holistically, looking at the experience of the worker involved, why they are right for the role, what the role itself involves, what skills level the role is itself. That said, there has been a huge amount of controversy about what is being considered as skilled and what isn't. And I think I've got on the next slide as well, maybe I haven't, but there is what's called the shortage occupation list, which allows the Home Office to add and take away roles that the UK is short of. So as you can imagine right now, we've got a lot of, you know, nurses and medical professionals that are very much that we're in need of here. So they can come in and out, and those positions, those occupations aren't necessarily what the Home Office will consider necessarily skills. I mean, nurses certainly, but other roles, they have that ability to kind of insert where they want to, when they want to, different jobs that they will allow. So it takes a lot of kind of, it's partly guessing to find that right fit. But yeah, this is where you do, on the whole, it's really, I don't want to plug my own services here, but I also do, but it really does help to have an immigration lawyer or someone who's experienced this a lot more and knows that kind of system and how it plays out, to really analyze from a caseworker's perspective how an application is going to be assessed. Does that answer your question on the whole? Yeah.
Yeah, I mean, it's perfect in with regards to just verifying against local workers with regards to, you know, can you hire somebody domestically? Because often it's the nuance, it's not on paper, like I say, people can look very similar. It's the nuance behind it that makes them radically different. So
yeah, absolutely. Yeah. And the Home Office is supposed to, the caseworker is supposed to recognise that. But it's all about fleshing out these applications so that you make it incredibly clear that this person is vital, is important, and needs to get to the UK now. So yeah, going into these points that I was talking about, any skilled worker visa applicant has to score these 70 points in order to tick all the boxes and get through to the next stage of being granted the visa. There's 50 points that are allocated in the mandatory criteria. So this is where you must have a job offer from a business, a company, an employer who already has a sponsor license. So absolutely key. You can't get sponsorship from someone who doesn't have a sponsor license. Secondly, it's that skill level that we've discussed a lot about. It's RQF level 3 or above. And English language is mandatory, can be really problematic. That's at level, it's called B1 of the Common European Framework for Language, for reference. B1 is generally basic business, if that makes sense. It's not basic English skills. It's more than that. It's you need to have kind of basic business skills in English language. So that can be a tripping point for a lot of employers. And yeah, then you've got, so that's your 50 points, tick, tick, tick. Then you've got to make up 20 points. And this is where you've got some flex. Those codes that I was talking about, and once you found your matching code, you'll see what the salary is. And this is another point that can be problematic. You've got a minimum salary. Sometimes you've got a new entrant salary, which can be lower for someone who hasn't worked in this position before and just left uni or something. But that salary remit has to be met unless you can trade for the points. So you score 20 points to make up your 70 if you've got 100% of that salary that they're asking for. If you've got 90%, then you're only going to score 10 points and you need to make up the other. If you've got 80% of the salary, then 0 points and you need to make up the extra 20. So how do you trade in these points? This is where I mentioned before a shortage occupation job. So they're saying that you can pay someone in the shortage occupation, whatever you want, low salary, keeping in mind with employment law requirements and minimum wage, but then they're not going to they're not going to refuse an application if you can't pay them that, if their job is in the shortage occupation list. So that's 20 points done. Also, they're wanting to recruit STEM and recruit for STEM positions, so science, tech, engineering, and maths. If your applicant has a PhD in that STEM subject that's relevant to the job, then boom, 20 points, that makes up for the salary. And yeah, then if you've got a swinging scale, then again, if they're a PhD candidate, if they've got a PhD that's relevant to the job, so aside from STEM subjects, but if they've got a PhD that's relevant to the job, then 10 points. So that's your sliding scale. Again, this is where there's going to be more subjectivity. Saying whether a PhD is relevant to the job requires your application to set out the reasons why, requires you to go into more detail about this role, about what it requires itself, what it entails. So it looks like a little maths system, nice little flowcharts and whatnot on the screen, but yeah, as Ollie was saying, those nuances, it's really important to consider them, to look at it holistically, and to argue in your application to the caseworker that that they should be awarded all of these points. So that's yeah.
Sorry, I've got a very quick question.
Sure.
Is this applying to teachers? For example, I work for l'Alliance Française and all my teachers are French speakers, obviously native French speakers. And for teaching, how does it work?
It depends on the type of teacher. This is something that maybe it would be good for me to go through with you afterwards, because I can show you the breakdown of the specific codes that can be linked to teachers. Yeah, because there'll only be a few, and that's can I ask who was? I'm not sure I can see who's. Hi,
it's me, Pat.
Hi, Pat. Hi.
Yes.
Yeah, if that's all right, if we link up afterwards and I can just send you some information, because obviously, I mean, the kind of people that you need to work for, it's going to be EU going forward and onwards and onwards. So yeah, that's definitely something that would be specific. So let me find the right codes for you and we can analyze that a little bit.
Okay, excellent. Thank you very much. Thank you.
No, of course. So moving to, okay, so we were talking about that skilled worker route, and yeah, the requirement to be offered that job from someone who's got a sponsor license. Possibly a lot of you are working with companies or own companies that already have these sponsor licenses set up. If you had that tier 2 sponsor license before end of December, or beginning of December actually, then it will have been automatically converted into a skilled worker license. So no need to act on anything. One thing I would say though, if you do have a sponsor license, it's an ongoing responsibility. You're probably well aware of it, but it would be remiss of me not to talk about it a little bit. This is one of those situations where the Home Office is passing over responsibility to an employer. They're sharing these responsibilities, so they're not the ones that are going to be pulled up, and they're not the ones that have to keep an eye effectively on employees who are who are non-British, non-settled here. So this responsibility, it's like a living, breathing thing. I don't want to freak anyone out at all. It's definitely manageable, but it just requires you to have specific procedures in place, things set up really nicely, nice systems to keep it running beautifully. You can do, I mean, certainly I'd be more than happy to run kind of health checks with anyone who's got a sponsor license, just to make sure that you're ticking every box. The Home Office can send out and do spot checks on businesses that have sponsor licenses to make sure that they're keeping up with the requirements and the demands of that license. Things like you've got to, essentially this is this license it's all done electronically. And once you've got your license, you have access to your sponsor management system, referred to colloquially as SMS. And yeah, so you've got set people in your business who you have to allocate at the start, at the get-go, who can access this system. So all electronic, fabulous. You've then got, you've got to have your allocated people to do specific tasks. And then it really links in as well with the employment law side of things. So your HR departments, if you've got them, keeping records, full records of your employees, of all your passport details, all done in certain ways. It's difficult now with the pandemic, and there are plenty of concessions in place. If you want to be aware of them, then please let me know and I'll go through it. But there's concessions in place whereby you can't be seeing someone attending the workplace every day necessarily, or if you're employing new people and you can't necessarily meet them in person, there are different ways to go about making sure that these checks are satisfied. Just really important that it is the sponsor license is treated as just that, a responsibility. It's almost, it's kind of, you're deemed worthy by the Home Office, therefore you have to keep up with their standards as life goes on. But as I say, it's definitely manageable. There's nothing to be afraid of. It's just making sure that everything is really nicely set up so that it can just carry on organically and tick every box. As far as getting a sponsor license is concerned, cost involved, time involved. This is what the government's kind of crib sheet is, which I'll take you through. So it's relatively straightforward, as long as you've got all your T's crossed and I's dotted. You provide, it's an application, online application that you fill out. You provide supporting documents, so it's things like proof of the place of business and who the owners of the business are, so on and so forth. You apply for that license online, set out why you need the license, set out who you're going to appoint within your business to manage that sponsorship and have access to that SMS system, who's going to be responsible. And it's an application fee. It's either £536 or £1,476, depending on the size of your business and the turnover of your business. So big or little business, basically, if you think about it like that. All the supporting documents get sent in, and then if it's granted, they actually initially grant what's a provisional license, which after 12 months, if you tick every box, then you can go on to have your full license. But the license is the life cycle of a license is 4 years. You have to renew that license before your 4 years is up or at the end, and it can be lost. You can lose your license if you're not keeping up with their requirements, if you're not carrying out your checks, keeping your records up to date, keeping records of your employees. So that's it says 8 weeks there. They have introduced a kind of fast track if you pay a little bit extra, classic Home Office, all about the money. So I think it's £500, you can get a turnaround of, I think it's 10 days. That might have changed recently, so don't quote me on that, but there is if you need a sponsor license pretty sharpish, then you can speed it up. Also worth mentioning, if time is of the essence, that it is theoretically possible to apply for your sponsor license at the same time as applying for your potential employees visa, and they'll just sort of be linked together a little bit. It can be a little bit tricky because you've got people applying from outside of the UK and whatnot, so but not impossible. If you're really down to the wire and time is of the essence, then it is something that can be looked at. And then, so once you've got your sponsor license, happy days, you can get your people applying, get your employees in. Again, more money, more time, and the application processing times depend on where you're applying from. Again, often priority fees. I will say that at the moment, because of the pandemic, all the priority services seem to have fallen out the window. Fair enough. So the waiting times are dragging on that little bit longer, but unless you're looking at that straight away now. Hopefully it's going to be, there's going to be light at the end of the tunnel and things are going to speed up a little bit. So you've got your potential employee or the person you've offered your job to, and they're going to apply for their visa. Again, it's an online application system, online form, pay your fee. The fee varies depending on how long they're required for, how long that job is for. They apply, I believe you've got to apply no more than 3 months before the job offer the job starts. And yeah, I think I talk about costs in the next page, so these are my issues with this category, but yeah, your salary level, it might not be tradable, so that's something to consider. English language, like I said, it's mandatory, so this may involve your employees needing training potentially, having to have English language lessons to get them up to that standard. The maintenance, so when you've got your sponsor license and then you've got your employee or a potential employee applying for their visa, they need to prove, they need to show maintenance basically. So there's 2 ways of doing it. Either they have to show that they've had £945 in their bank account for 90 days before applying, which, depending on who you're looking at, it is quite a lot to have sitting in one place potentially. Or a sponsor, so the company, for example, can tick a box on their application form to say that they certify the maintenance, effectively saying that they're covering, costs for accommodation and food for the first month. So that can be part of an initial pay packet depending on who it is you're employing. But just something to bear in mind, thinking about these EU nationals that would previously be coming here, for example, for coming for work, that is a lot of money potentially that wasn't required to be shown before, and now it is. And then the costs involved with EU nationals, when there's never been that cost before, it's now it's really racking up quite quickly. Sponsor license fee, as I've said, between 500, it's either 536 or 1476. There's also this immigration skills charge, which gets added on when you've got someone to sponsor, when you've got an employee and they're applying for the skilled worker visa, then they charge you this skills charge of £1,000 a year. There are some variations a year of what they're going to live here for. So yeah, it's really not cheap. There's also the immigration health surcharge, which you may or may not have heard about. It covers a huge amount of different visa categories for people coming to the UK. If they're applying to come here to live, then they have to pay a mandatory immigration health surcharge. It's supposed to go directly to the NHS. It's really gone up in price through the years. Currently, it's on the whole standing at £624 per year. So if someone's applying for a 5-year work visa, skilled worker visa, and you've got £624 times 5, plus all your other costs, and this is all before I get to the application fee itself, either £610 or £1,220, depending on how long they're coming to the UK to work, how long the job is for. So yeah, and just to go back to that health surcharge, what that gives the applicant is full access to the NHS, the same as someone who's British or someone who has that permanent residence or indefinitely to remain has. Not that the NHS will ever turn anyone away, but that covers you. So yeah, another bee in my bonnet about people who say that, people come here and abuse the NHS from different countries, but invariably they've had to really fork out and pay a huge amount of money. You've often got people who are coming who've already got health insurance as well. So then you've got your immigration health surcharge doubling up with the health, and there's no concessions as well. If someone's got health insurance, they don't care. It's mandatory. You have to pay the immigration health surcharge. So it is pretty astronomical costs at the point of application. So yeah, these are important factors for a business to consider and to kind of allocate for as well if you've got people coming in. I'll move on to the next slide. So yeah, a couple of a couple of questions that get asked a fair bit, and this is just going back to just focusing on EU nationals on the whole. Right to work checks. Yeah, this is again, like I said before, the Home Office branching out and putting the responsibility, putting the onus on employers to do their job effectively. And employers are required to carry out these right to work checks and make sure that their employees have the right to work in the UK. So people who, if you've got EU or EA nationals working for you now, do you need to carry out right to work checks yet? The answer is no, because we've got that June deadline. Nothing needs to be looked at now as far as asking for what's your permission to work here, etc., etc. They're protected until that time. So it's only after that June that you can start to say, right, I need to see your residency documentation, your confirmation. So if you're an employer, it's kind of nothing, everything. So that's where I would really suggest just keeping that open communication with your EA employees, your EU employees, offering assistance where possible to apply for the EU settlement scheme, setting up computers even, or just making it a kind of getting in advisors to sort of run it as a sort of conveyor belt one day and just make sure everyone's got their applications in, just offering that, not making it mandatory, of course you can't, but that can really help you maybe to put your mind at ease that everyone knows where they stand, everyone knows what they've got to do, and hopefully make it a less potentially stressful experience for your EU EEA workers. Another question, can we insist that our EEA national employees provide evidence of their status under the EU settlement scheme? Again, no, that I mentioned at the beginning. You can't you can't request evidence. It's a matter of UK employment law. Definitely don't. It's you don't require it yet, and B, it's, yeah, you can get stung employment wise. So that's something that you can't do until post June 2021. Yeah, new employees joining from January 2021. It depends, because they may have already been working here before, they may have already had their settled status confirmed months ago, last year, or they might have just come to the UK. So this is where there is a window of, it's again a concession, where employers are a little bit protected from being stung by the Home Office, essentially, because you do have this window before June 2021 when you can't be demanding to see evidence of EU status, but at the same time, if you've got someone who is who it all comes down to the knowledge of the employer. If you know and you have knowledge that that person actually flew in and used to live somewhere else, flew in last week to start this job, then that's where you have to ask for your evidence, because they haven't been here before. So it's a really difficult one, a difficult position for employers to be in. If you're in any doubt or worry, then ask, have it on record that you've looked into it, you've taken advice. But on the whole, yeah, it's about your knowledge, your prior awareness of what the situation is with this particular employee. And yeah, will we be penalised if we rely on an EA passport for right to work check before July? And then yeah, so if you've got someone who, saying again, you're not allowed to demand that people show you their EU settled status, and if you don't know otherwise, and they say, oh well, look, here's my German passport, I'm a German national, but then ultimately it transpires that they never had a right to work, or they potentially lost their right to work. It depends, and that's the same as the last question. It's all about your prior knowledge. So very, very difficult. If it gets to the point of the Home Office kind of asking questions and things, keep records of everything that you've done, everything that you've looked at, everything that you've considered. If in any doubt, take advice and have a record of that as well. And so, will EEA nationals who qualify under the settlement scheme and don't apply by the 30th of June deadline lose their right to work? Yeah, potentially yes. And this is where it goes back to my crystal ball. there's going to be a lot of litigation. We're going to have a lot of people who've been here for many years and just for whatever reason do not make these applications. The blowback on employers it's going to be very interesting. So these people can potentially lose their right to work. And it's yet to be seen how it's going to play out, how many court cases we're going to have, how many tribunal appearances we're going to have for people who didn't know, didn't apply, whatever reason. As far as employers are concerned, yeah, that is going to mean that you can't employ them anymore, or it could affect you. So it's all down to that 30th of June deadline, and important to stay aware of that. Okay, so yeah, I think I've drilled this home a little bit, so bear with me. What I'm really wanting everyone to take away from today is EU, EA nationals, who yourselves, or if you've got employees, if you've been here before December 2020, apply for that settlement scheme. I generally say, not to scare anyone, but the sooner the better. There's 3 outcomes. You can either have the status granted straight away, you can have it rejected, or you can be asked for further information. That further information, that toing and froing, it can take a really long time. So, I mean, you're in the system, great, but everyone wants to get this sorted pretty sharpish. So the sooner the better, and it's nothing to be afraid of. It's relatively straightforward. The application themselves, maybe people have done it, maybe you haven't, but you download this EU Exit UK ID document check app. So it does require you to have the right phone, but you can do it on anyone's phone, or at Chatterton's, when we're meeting again, I can do it in a meeting room with someone. You take your photo, you scan your ID documents, so your passport normally, and enter in some details. So the general things they're looking for is, national insurance number, any tax references, date when you first started living in the UK. And it can be pretty quick and can literally be, fill it out for 10-15 minutes max and submit, and they might not need to see any more documents. It really depends on the situation, but nothing to be afraid of, and it's free. So just, no excuse to just get it done, just get it sent off. And then if you've got, other non-UK workers, non-Irish workers who haven't been here before end of December 2020, explore the cost and the timeline of alternatives. And it's all about managing expectations, both of people that you're wanting to employ and the employer, looking at the cost, looking at what's available to you. And of course, stay updated with me, take my details, check in if you've got any questions. Pat will talk as well. And I'm always welcoming any kind of inquiries. I'm really passionate about this, particularly this area and with this time frame right now. So it's raising awareness, getting people aware of what needs to be done. And if anyone has any questions at this point, then please let me know. Pat, obviously, thank you so much for your question, and we can discuss either via email or whatever afterwards as well. But opening up to the floor if anyone has any questions they'd like answering now.
We go with the standard 5 seconds on Zoom for people to get off of mute.
I probably talked everyone to the ground. So
no, but me, I have this question. Sorry, again, it's not about teachers, it's about students. We do have trainees who comes to work with us. They're students from France, and they stay with us between 6 and 8 months every year. And they're not paid, obviously, but how do you consider what is happening? How does it work?
That's going to be a difficult one. That's a difficult one. I do worry that's where we're going to find that there's not going to be, because in terms of, there is this sort of charitable short-term worker visas that we can potentially look at, but off the top of my head, I can't really see whether that would be applicable. Seasonal worker wouldn't apply. again, it's all fitting into this menu of options that are actually quite limited once you delve into them. I mean, I don't suppose if they've been, we could look at the frontier worker permit, which would be really max 6 months per year that they could go on coming back for. But if they're
even as a student, because if they are a student in France and they do have like some sort of we call it a convention, some who said that they are student and it's a partnership with us, we will have to be, as I see earlier, you talked about this visa or that we need to.
So they're students overseas. They're not getting paid here. Are they employed? Are they technically employed, or is it very much kind of voluntary?
No, they are volunteers.
It's volunteer. Yeah. I mean, thinking about also just coming as visitor, you have to be really, really careful with coming as a visitor, but potentially it's, again, Ollie's word, nuance. It gets into the real little nuances of what the work entails and how we can fit that into one of the categories as best we can.
And I had another thing. If you have a company, a charity or whatever, a company, but you have someone who works for you, but from overseas online, how all of this works then?
I mean, wanting to come to the UK?
Well, for example, for me, I give online classes and I could get some teacher from any countries in the world working for me, because all our classes are online now.
Yeah, really interesting one in the modern world. I mean, physically speaking, they're not in the UK. So this is where you can potentially get stung if you're sitting in the UK and working for an overseas company, but carrying out your work remotely from the UK. But because they're not actually going to be physically on UK soil, the immigration side of things falls away. They're not going to require immigration status in the UK to work. It would be more a case of looking at where they are and do they have the right to work in that country. But if they're in that country, that would be fine. So that's not going to be a problem for you or for them. But it just shows with the remote working now and how things are happening, how easy it is to work remotely, but how quickly it can get complicated when we're looking at what your rights are. Also tax, just to drop that in there as well. That's something that always gets flagged up with workers and wherever they are, and if you can have a tax man knocking on your door. But for those people that you've mentioned, I don't see that it being an issue, but worth flagging up if people are coming to the UK as visitors, sitting in their office, in their friend's office, sitting on their computer, doing all their calls, doing all their work, carrying on as normal, and they do this regularly and someone knocks on the door, it could be potentially a problem.
No, that I understand, but it was more for me as a volunteers. If you come to work as a volunteer, where just at all.
Your volunteers and your teachers is something that I'd like to take a little
because exactly, because for teachers it's going to be a real nightmare with all the skills that is asked, and money wise as well. You see how expensive it is for the annual salary. It's mad.
It just goes up, and that's on top of the sponsorship itself. So,
but anyway, sorry.
No, honestly, Pat, I'm with you. It's going to play out in years to come how we see everything fluxing and whether more needs to be done and more needs to be opened up by the Home Office. But it's a shock to the system.
Sorry, I have another question. If my husband worked for a big company here in Cambridge, and they have a lot of people from Europe who works for them. It's just a question like that. If you don't find people here in Great Britain who feel the work, what's going to happen if you don't have the skills here in the UK to have these people working for you? What do you do? What is the way out?
Yeah, so this is where it's all coming under that menu of options. So working in the UK would be, yeah, your skilled worker visa, paying all those costs and fees, making sure they fit into the categories, or if it's a different type of work, looking at the different temporary options and whatnot. But yeah, it's going to be, it's a hell of a lot of extra work and money.
It's money is mad if I see what you. But anyway,
and that's exactly what I mean about, you know, managing expectations and setting aside, looking at your finances, looking at projections for the next 5 years and onwards, to make sure that there is space allocated for this huge financial impact, to retain the talent and to take on the talent.
Kate, I'm going to just interrupt there only because we're 8 minutes past the hour, and I've noticed quite a few people have dropped off. Just purely to say that you have a hugely arduous task ahead of you towards June time this year. There's a myriad of information there. I think the answer is, if in doubt, reach out. That's really what we're saying here. And the devil's always going to be in the detail with these things.
Absolutely. Summarize.
Really appreciate your time to walk through that. We'll absolutely make sure that we share your contact details.
Yeah, put them on there. Yeah, they're on the screen there.
Awesome. Earlier, I'm just going to take a screenshot of those. I'm sure Sadie's got them anyway. But I'm guessing, in order to keep Kate's sanity, reach out sooner rather than later, so that you don't get a tidal wave of inbox demands towards the middle of June, would probably be the best answer, right?
Sure. Yeah. I mean, sooner rather than later with regard to anything. It's all about planning. It's all about getting ahead of the game as much as you can. So yeah, get the advice as early as possible. And I'm here, and yeah, welcome any inquiries. Just let me know.
Awesome. Really appreciate it. I'm just going to hand over to John. John, do you have anything to say to sort of wrap up the session today?
No, just thanks to Kate for a very complex, challenging topic, and even more challenging to the people that are on the end of trying to implement it, or it affects them personally. But it's really great, and thank you very much, because it is a bit of a minefield, and the key thing on all these things is to make sure you get good advice in plenty of time, to make sure that you can make sure that you're secure, and that you do all you need to continue to be able to operate in the UK and bring your people across to the UK. We may not agree with some of the aspects the government actually implement, but what we can do is help people to comply with it, regardless of what we may think about it. So thanks a lot, Kate, and also for Ollie for hosting the session for us, which we do appreciate. Thank you.
Thank you, Ollie.
You're welcome. Thank you very much. Pat, sorry to cut across your questions. You sound like you've got an awful lot to address with Kate, but yeah, thank you, everybody. We'll circulate the recording around as usual. We'll make sure that Kate's details are in your inbox, and please reach out earlier for the sake of Kate's sanity. Thank you. Take care. Have a good day.
Bye.
Bye-bye.
Bye-bye.